Yeah, that's right. It's Monday. You're tuned in. It's Law and Legitimacy. Mike and Norm are back for yet another week in the saddle, commenting on this, the best of all possible worlds. Is it beginning to look a lot like Christmas out your way? It's starting to look like a hellscape here in Connecticut. I got into the office a couple hours ago, through the driving rain and detritus all over the road and trees down, and they say that it's even going to get windier. So I reached out to the judge I'm supposed to appear for this morning at 9:30 on a sentencing. I said, "Is the Department of Corrections going to call in sick today because all the schools have shut? It's just too windy to be on the road." And the judge said, "Let me check before you leave your office." So we'll see. But Merry Christmas, everyone! I hope you're getting ready for the holidays. Mike and I will be taking next week off as we announced last week. We'll be meeting. We'll be meeting to discuss what it is that we want to do with this site in the year to come. We've made a lot of promises along the way this year that we haven't kept. We started talking, or I haven't kept, started talking about a con law textbook, and I crapped out just because I got so busy doing one thing or another. And these little breaches of commitments can cause people to lose faith in us. So we're going to re-examine them. We're going to make a better effort to marshal our resources and do what we can to make this page soar, because God knows we need something to believe in this world, especially as the 2024 electoral season begins in earnest. The first primary or caucus rather in Iowa is January 15th, and then we will go rapidly through the beginning of the year. And before you know it, we'll have two candidates asking for your vote. And there is a view.
Maybe.
The good citizens vote. Sometimes you got to wonder, But let me tell you what I'll be voting against this year. I'll be voting against the incumbents because I am just so filled with disgust at the Justice Department. And here's an example why. You will recall a year ago at this time, in fact, a year ago tomorrow, we began jury selection in the Proud Boys case in Washington, D.C. It took 13 days to pick that jury and 85 trial days to get that trial done. I left the office in late December, didn't return until mid-May. And when I returned, my junior partner decided he didn't want to be here no mo. And I've had to reconceptualize and rebuild and rebrand the firm. And we'll have some announcements soon on what that will look like. And I'm pretty excited about it. But here's what jurors were, or when we opened court every day, Miss Harris, the court deputy, would say, present is defendant number one, Ethan Nordine. Defendant number two, Joe Biggs. Defendant number three, Zachary Rell. Defendant number five. And I always wanted to say, wait a minute, where's number four? There were five defendants on trial in the Proud Boys. They were all lumped together in the indictment, in the superseding indictment. I think it was the third superseding indictment, the indictment being the charging document. On trial were Joe Biggs, Ethan Nordine, Zachary Rell, Dominic Pizzola, and I am drawing a blank on the fourth name. That's really a sign of a
Enrique
senior.
Tario.
Enrique Tario, yeah, the leader of the pack, the El Presidente.
Well, he wasn't there,
Well, yeah, but he was at trial. But not seated at the table was defendant number four, Charles Donohoe. Charles Donohoe pled guilty early in the case, but he was one of the leaders of the Proud Boys, according to the third superseding indictment. He was on the government's witness list, but the government never called Mr. Donohoe. And we suspect they never called him because what he told the government, according to documents released to us, is there was no plan to engage in seditious conspiracy that day. What happened spontaneously and was an eruption of people overcome by the emotions of the moment. That would have been useful testimony for us. So they kept Donahoe off the stand. We didn't call him. He was a government witness at that point, and we believe that he had a cooperation agreement with the government where he, basically said, "Look, I'm going to give you what I can to get what I can in the end. I don't want to go to prison forever. I'm sorry. Please have mercy on me." Well, boy, did he get it. He's going to be sentenced, Charles Donohoe, Proud Boy number four, tomorrow on December 19th, 2023 at 10 a.m. in the aptly named Prettyman Courthouse. I've always thought it was ironic that the Proud Boys go to trial in the Prettyman Courthouse. In the sentencing memoranda that the parties gave to the court last week, something remarkable occurred. Mr. Donahoe was represented by the federal public defenders. They called for a sentence of 36 months or 3 years, well below what the Proud Boys who went to trial got. The government filed a sentencing memo in which it basically said, well, his sentencing guidelines, that is, what is presumptively reasonable according to the guidelines published by the Federal Sentencing Commission, call for a sentence of 70 to 87 months, but we think he should go to prison for 35 to 43 months. In other words, the federal defender and the public and the prosecution basically agreed that 3 years is the reasonable sentence for Mr. Donahoe. Notice what didn't get put in the government sentencing memo, and Mike has it up there. There is no enhancement for terroristic activities. You'll recall my going apoplectic about that at various points on this broadcast, because there was no terrorism here. Under the federal sentencing guidelines, the government can ask the court to enhance a penalty if it meets the definition of terroristic activity. And to be terroristic activity, the offense has to satisfy certain predicates, and those predicates being the commission of another offense that is related to terrorism in the eyes of Congress. Of the 45 or so other offenses, all but one are catastrophic: assassinating a public official, engaging in using weapons of mass destruction, bringing an airliner down, bringing the airline system down, using computers to cause mayhem. But then there's one: destruction of property. And if you destroy government property in association with another crime in an effort to influence government, you're a terrorist. So Joe Biggs, the court held, was a terrorist at the government's request. Ethan Nordine was a terrorist. The court found at the government's request. Enrique Terrio was a terrorist. The court found at the government's request, and likewise with Dominic Pizzola. Donahoe was also involved in these same activities. And in the government's sentencing memo, they asked for a $2,000 fine because of the destroyed property that day on January 6th. And they note that the maximum calculation of value for damage to the Capitol on January 6th was $2.9 million. This was not, millions. Well, it was millions technically, but when you say millions of dollars, you're thinking tens of millions, not 2 or 3 million. So here's the irony. Donahoe was a leader of the Proud Boys. Donahoe was charged with the 5 men who went to trial. Donahoe pled guilty because he said, I am guilty of the offenses. Donahoe destroyed government property. The government seeks restitution for from Donahoe for the property he destroyed. But the government did not seek to double his sentence with a terrorism enhancement. Why? Is it because he went to trial? Is it because he didn't go to trial, rather? Did the others get sentenced to be designated as terrorists, rather? And I'm telling you, this carries consequences in their travails and travels through the federal penal system, because, DOC people, Bureau of Prisons people look at this and say, wow, this guy's a terrorist. He's pretty serious. We better keep an eye on him. You're not a terrorist if you destroy a fence. And if somebody who goes to trial is found a terrorist because he destroyed a fence, how come somebody who pled guilty, who helped destroy the same fence, isn't a terrorist as well? One conclusion, and it's the conclusion I've reached, is that the terrorism enhancement was used to doubly penalize people who stood on their constitutional right to go to trial, and to say, look, I may have been involved in trespass. I may have been involved in unruly behavior on the Capitol, but I didn't engage in seditious conspiracy. They went to trial. A jury convicted them, and the government called them terrorists. Donahoe pled guilty to the same conduct, and the government decided he wasn't a terrorist. The only variable, he didn't go to trial. Now, plenty of the government sentencing memo is redacted. I don't know if you've seen that in the stuff that Mike was scrolling. There are things that the public will never know based on the documents filed in court. The government blacked it out so that we couldn't see what transpired between Donahoe and the government. And so once again, the public's right to know is being hampered in this cherry-picked set of proceedings where Donahoe's relationship with the government is kept secret from the public by means of these redactions. There's an example. Beneath those blocked out sentences are sentences written that probably say he offered to cooperate. He gave substantial assistance to the government. He provided information that was materially useful in the prosecution and conviction of others. They don't want to write it in the PSR because somebody might get the wrong idea. Somebody might come to think that maybe Donahoe was a cooperating witness, or in jailhouse lingo, a rat or a snitch. Oh, they don't want to do that. They want to take care of the guy who pled guilty, and they want to punish the ones who didn't and were found guilty of the same offense. So, those of you who ruminate about the trial tax as I do can consider this as further examples of it. Donahoe will be sentenced tomorrow. My hunch is that Kelly will probably give him 3 years or thereabouts. And I think it's a sad contrast to what happened with Biggs, Tario et al. These men
Just
received
to illustrate what
sentences
you're
in the
saying.
17 to 22-year range.
Well, and sorry to interrupt there because
That's
that's,
right.
that is by comparison the 17 to 22 year range, but here is here's one part of the redaction that's really interesting and supports your conclusion that, it was his offer of testimony that guaranteed his low sentence, and look at the amount of redaction here in conjunction with what's said at the end. Um, this is, mitigating circumstances ultimately. And it's redacted, redacted, redacted. Donahoe has exhibited a fundamental respect for the law, and Donahoe has acknowledged that there is no justification for his actions on January 6th. Based on this history, it is unlikely that a lengthy additional period of incarceration will materially alter Donahoe's respect for the law and likelihood of recidivism. The rest of this document prior to this talks about how involved he was, and,
And it committed to violence, and the Proud Boys being the
a
vanguard of
criminal
violence.
collective, right? It was a phrase as he was central to a criminal collective,
To
right,
the
that
degree that
conspired.
federal sentencing is intended to promote respect for the law, nothing in the Proud Boys prosecution did so, in my view. I spoke last week to one of the prosecutors in the case, who shall go unnamed. He doesn't need association with me publicly. And they said, I enjoyed the trial with you. I missed you. Happy holidays. And then we talked about some other developments in related cases. I wanted to ask him if he really believed in what he was doing. Um, um, and he didn't. I said, but I have respect for you as an individual, but I despise your client. I think the Justice Department should be defunded with respect to January 6th. And I don't want to become a January 6th podcast, but there's a second January 6th story that I think we should be, that at least informs my disgust with the enterprise. Steve Baker, a journalist with the Blaze, has been instructed to report, to turn himself in, to self-surrender tomorrow on J6 related charges. Now, Blaze was covering the January 6 riots. Baker was present at the Capitol, and he reported on it at the time and thereafter. In particular, he has raised questions about the credibility of a key government witness in the Proud Boys, or excuse me, not the Proud Boys, the Oath Keepers case, David Lazarus, a Capitol Hill police officer, who identified Oath Keepers as present and engaged in violence without corroborating video evidence. And Baker has raised questions about whether Lazarus really saw what he saw, whether he was credible, and so forth. And now the Justice Department isn't just calling him in for a little chat. They're calling him in, presumably to charge him with crimes that he's not yet been notified of, at least in public. There are guidelines that the Justice Department is supposed to follow in evaluating whether to arrest a journalist for criminal conduct that took place in the course of the journalist's employment. And those guidelines were ignored in the Owen Schroyer case. When we were first presented to a federal magistrate judge, the magistrate judge raised questions with the Justice Department about whether Schroyer had been run through that guideline process. The Justice Department ducked the question. I hope Baker's lawyer raises that question, and we certainly raised it. We never got answers. We cut the deal that we did to avoid worse consequences as a pragmatic matter. But there is something troubling about the Justice Department arresting journalists years after the event, when they knew he's been there for 2 years already, and they're arresting him now only after he has become highly critical of some of the testimony of key government witnesses. This almost looks like a lawfare. This almost looks like they're signaling Baker out for prosecution because he's a critic of the regime. And I don't want to sound like a conspiracy theorist, but sometimes reality just slaps you in the face. And sometimes if it looks like sometimes if it feels like they're out to get you, it's because they are. And in the Blaze Baker case, I think the Justice Department is targeting a critic of the regime who they had probable cause to arrest for years. But when he wouldn't shut up, they decided to sit him down and probably lock him up. I mean, this is outrageous, Mike.
Yeah, in particular, I think that what Steve Baker has been critical of is the testimony that was used to secure the convictions for seditious conspiracy in the Oath Keepers trial, right? That is key testimony of Capitol Police Chief. I think it was the Capitol Police Chief Lazarus, and what he says happened on that day in comparison to what Steve Baker has offered, based on his review of video footage, right? And that perhaps what he was saying in an effort to give the Justice Department what it needed to secure these convictions may have been less than the way he described it, right?
Well,
That
I
is
don't
that
think.
to me is the interesting and more narrow point of this journalistic effort, and why Steve Baker is under the microscope is that he serves to undermine the credibility of the prosecutions in total.
So, seditious conspiracy, for those of you who don't recall, is an agreement among two or more to use force to oppose the authority of the United States government. That's all it is. The folks, for example, out in Portland who nightly, bombed or rocketed high power fireworks at the Portland federal courthouse were probably guilty of seditious conspiracy, more so than the fellows who were arrested on January 6th. No prosecutions there. Oh well, I guess justice can be blind, deaf, and dumb all at the same time. But with respect to seditious conspiracy in the Oath Keepers case, the officer's testimony, he wasn't the chief at the time, was that these men had engaged in the use of force at the top of the Capitol steps. And that helped prove a key element of the sedition charge, that is, the use of force. Baker's like, yeah, I don't know. The evidence that I'm seeing, the objective evidence, looks like Lazarus wasn't truthful. And if the key witness for a pivotal element in the seditious conspiracy charge is not to be believed, that raises questions about the charges in general and about the integrity of the party, that to wit, the United States government that brought those charges. We'll report more on Baker's case as it unfolds. Blaze is a journalistic enterprise. It's different from Infowars. People like to denigrate Infowars as a sort of right wing conspiracy shop. There's plenty of content on there that you can characterize in such a way. Plenty of it that's just flat out reporting from a different perspective. Blaze is not quite in the same category in many people's minds, the Blaze, as Infowars. It's closer to what we might call legacy media. And the Justice Department's decision to target a Blaze reporter in this manner should raise the hackles of reporters everywhere. But I kind of doubt it will. And, while we're on the topic of Infowars and the mainstream media, I gave up over the weekend. There, Alex Jones was went to follow his doctor's advice, didn't go to a deposition. The other side moved for an emergency order. This was in the Sandy Hook case, that he attend the deposition. The trial court rejected Jones's doctor's letters, which were sworn under oath, and said, no, you got to go. You appeared on the air. You're disregarding your doctor's advice. Therefore, you're disregarding my order. I'm going to impose a fine on you of $25,000, and it's going to go up by 25 every day until you attend the deposition. Jones deposited 25,000, then $50,000 with the clerk of the court, then attended his deposition. And then the court gave him the money back. So, but yet every newspaper that commented on, and he took an appeal and lost the appeal. We lost the appeal last week. Every newspaper, appeals court rules against Jones, upholding $75,000 fine after missed deposition. Folks, Hill, New York Times, everybody else, that sound is me pulling your head out of your ass. Okay. There was no $75,000 fine that was paid. He put 75,000. If he hadn't attended the deposition, that fine would have cascaded to $1.5 million or thereabouts. But he put money into the court. He went to the deposition. The money was returned. The appeal was taken to challenge the contempt finding and the $23,000 or $24,000 in attorney's fees that that the court granted plaintiff's counsel as a result of having to pursue their motion to compel his testimony at the deposition. So once again, the media sees what it wants to see, and then they flock together, feeding off of one another, reading one another's headlines without anybody really even reading the documents in question to determine what the truth is, because the truth doesn't matter. And they call it.
Spectacularly incurious
Yeah,
about
they call
issues like this.
they
It's
call
fascinating to me.
they call Alex Jones the conspiracy theorists. I don't know. I don't know. Interesting news out of the Second Circuit in New York City this past week. In Connecticut, litigation has been underfoot for a while, where women, that is, young ladies. I realize that there's at least one member of the United States Supreme Court that couldn't tell us what that is, but I think most of us know. Girls wanting to compete against other girls in their schools raised litigation about the schools permitting guys who pretend to be women from participating in their sporting events. Now, I'm not, I mean, those of you who are serious students of gender identity will be upset with my manner of characterizing this. Guys pretending to be women. Okay, there are people who may have genuine gender dysphoria, people who genuinely may have confusion about what gender they are, and they may have been born male and come to regard themselves as women. But how I regard myself doesn't make me what I am. I will no more be starting quarterback for the University of Michigan Wolverines football team in their game against Alabama this week than Mike's team will make it to the playoffs in the
Listen, I've
Law and
seen your
Legitimacy
five-step drop,
fantasy
Norm.
football team. Yeah,
I've seen your five-step drop, Norm. You're
yeah,
not that
yeah.
far.
Oh yeah, my 5-step drop is like from the coffee machine to the restroom. Can I make it there on time? So the in order to bring a lawsuit, you have to have standing, and a district court judge had concluded that biological females didn't have standing to challenge the right of men identifying as women to participate in female sports. And so they brought an action under Title IX. It took an en banc proceeding of the United States Court of Appeals for the Second Circuit to come to a conclusion in this case, and that is that they do. And therein lies the pity. It's the Cass Sunstein has a really fascinating new book out on how to read the Constitution. I'm listening to it as I drive around the state on my rounds these days, and he says, matters of constitutional interpretation are difficult, and there are differing ways to interpret the document. It's not self-executing, as it were, nor does it carry within it canons of interpretation or means of interpreting it. These are decisions we have to make, and his view is that we should choose that which makes for the best possible republic, the best constitution, the best life for all of us. And he notes how quickly our standards change. 20 or 30 years ago, there could not have been gay marriage as a matter of constitutional law. Now, no serious student of constitutional law will say it's not the law, because it is. And you may disagree that it should be, and you may say that reading the document and the history of it should yield a different conclusion. But in doing so, you're bringing assumptions to bear to the document that are not in the document, and you have to own those. And I think Sunstein's objective is to get us to have a reasonable discussion about the manner and means we choose of interpreting the Constitution. I go down that rabbit hole just to say that in the case of transgender students participating in sports, 10, 20, 30 years ago, a guy wanting to participate in a women's team would have been laughed out of court. Now, the women who want to protest about guys participating in female sports have to fight to the tooth and fight to the death for their right even to be heard. And en banc, usually when a case is heard in the Second Circuit, it's a 3-judge panel. If you don't like the result, you can ask for the entire court to hear the case. And in extraordinary cases, the court does. It took an en banc panel of the second highest court in the land. This is just one step removed from the United States Supreme Court, to determine that women had standing to challenge men participating in their sporting events. Wow. I just think the world's spinning off its axis, Mike. I don't know what to say beyond that.
We've seen this developing around the country in various sports. I've seen a lot in mixed martial arts as of late. Of course, we've seen it
Mhm.
in swimming primarily. That was a lot of people's introduction, at least from a mainstream perspective, to the issue in full. And we've seen this sort of issue manifest at varying levels, right? I think that we understand that children's recreational athletics almost by necessity is sort of co-ed at the beginnings of
Yeah.
competitive life. But at a certain point, it becomes obvious to anybody with a functioning frontal lobe that young boys and young girls develop physically at far different rates, and girls often outpace boys in that respect. But when boys begin that arc to catch up, that the physical dominance in on average in sports and athletics is incomparable. And what is interesting about this to me is that we have somehow suspended that because at least in recognizing that this is only going one way,
Yeah.
right? There aren't a tremendous amount of females that are transitioning into males who desperately want to compete with males, um, biological males in athletics, right? It's going one way. It's an obvious competitive advantage for those who have been yielded the benefits of puberty, right? Young men who have been given the benefits of puberty just through natural evolution here, and then are able to outcompete and deprive young girls and young women of the merit uh, of winning these competitions in varying sports. Norm, I just think that what we are doing is really disemboweling any of the parity or equality that has been sought for by and through the last several decades of advocacy, right? Parity in Title IX, right? What are we doing now to young women? What is society saying to young women, right? So I think it was Riley Gaines who was at the congressional hearings. And I believe everybody's probably seen, the representative that moved to have Riley Gaines, remarks to her stricken, right? Uh, because Riley Gaines pointed out and said, if you want to call me, whatever, I will call you a misogynist,
Yeah.
right? And I think it's really interesting to say that. So
You know, I hear you.
anyway, I don't
I
know
hear you.
what's
Well,
going
let's keep
on.
an eye on that. I don't know. I mean, I'd say it's just it's a problem of biblical proportions. It's we pot saying to the potter, "Why makest me thus?" In an era dominated by will, without any corresponding sense of reality, the need for grace, the need to recognize that we're all created, not made by chance. It's of course natural that people will conclude they can be whatever they want to be, and then they'll seek to bend, twist, and warp society in that direction. Hey, I want to switch. I know we promised to talk about the Bronx defenders and whether they should be defunded. I'll make that case tomorrow morning. But I want to end today on a sad and a somber note. Law and Legitimacy lost a good friend last week, Justin Carta. He's about 47 years old. And I got a note Saturday from someone who was close to him saying that they hadn't heard from him in a couple days. They popped by to do a wellness check, and he was dead in his bed. So Justin Carter was somebody that surfaced in my life a couple years ago when I was approached and asked if I would consider running for the U.S. Senate. Justin said, "Yeah, you should. You should. I'd be happy to help." And he introduced me to people, and we became gab friends. And we began to talk. I met him at a couple comedic events, and helped him with his employment issues, and just basically checked in on him, and he checked in on me. It's funny. I was having a discouraging week last week for one reason or another, and I said something to him in a note, encouraging him through his difficulties because he was between jobs. Some days it's this is almost prescient. Some days it's a triumph just to get out of bed in the morning. And he said to me, "Buck up! Don't you go anywhere. We'll be needing you." Little did I know that that would be one of the last texts that I would receive from him. Come to find out that Justin had a history of heart issues. He'd had some valve replacements years ago. And I gather his clock just ran out and his time expired, as all of ours do. But, Justin, if you can hear us from somewhere, and I don't know what my faith holds about that, we miss you. And we really appreciated your support. Justin was trying to get us a spot on the podium at CPAC this year. He had connections there. Justin, your loyalty, your grit, your good sense, your refusal to tolerate bullshit in your life or in the life of your community will be sorely missed. But most of all, Justin, what I will miss is just hearing from you. knowing that I had a friend out there who thought and sought to connect with me, just on a human level, no matter what we were doing, because after all, we are all alone in the universe. And when you find a spark of divinity and a spark of connection in another person, it's impossible not to want to warm yourself near that spark. Justin, I don't believe, had children. He was single at the time of his death. He has family in California. There'll be memorial services in both California and Connecticut. Justin Carta, thank you for the love, respect, and support you showed us. You died a man much loved, and we will miss you for the time, for a long time to come.
Well said, Norm. Justin was somebody that made himself known as a supporter, unequivocally so. He reached out on social media constantly in direct messages, offering encouragement, offering inspiration for our subject matter and discourse, Norm. Made it known to me in much the same way that he made it known to you that what we were doing here was important. And I think that he is an underappreciated, or heretofore has been an underappreciated asset to us as men and as friends and as a community. You could find him throwing our content into every single conversation possible on X. It didn't matter who he was speaking to, their level of fame, um, or influence. He didn't care. He saw us as a cornerstone of where we should be going as a country, and was unwavering in that respect. And I was given his respect by virtue of his respect for you, Norm. So when you called to tell me the news, I was hit and felt a bit guilty, if I'm very transparent, um, that I'd never fully appreciated, or at least expressed to him how much his support meant to us. So, um, wherever you are, Justin, thank you for that.
The good book says it is appointed unto men once to die and thereafter the judgment. Justin, we'll leave it to God to judge you. Our judgment is you were an angel among us, and we are grateful for walking with you. I see Janice Dombrowski. Oh no, no, no! She says, I know that they were acquaintances as well. But farewell, Justin Carter. Funny thing is, I could never get his name right. I call him a friend, but I was always calling him Jason. And I guess I did it last week because I got a note, Jason. And I wrote him, I said, why don't you just change your name and give an old man a break? You're always going to be Jason to me. And now I'll make this special effort to get it right. Does it take death to make me want to get it right about things? I don't know. It's a wake up call to all of us. Let's appreciate one another. Life is short. It's the holiday seasons. And Mike, where do people find us, and where will we be tomorrow morning at 8 a.m.?
We will be right here on YouTube, on Rumble, and on X at Law Pod Daily. We're here every day, 8 a.m. Eastern Time, Monday through Friday. You can also find us on Apple Podcasts, Spotify, Google Play, Overcast, wherever you find premium podcasts. This has been a somber ending to start the week here of our stream, but I have a feeling that Jason or Justin, whichever one he's going by in the afterlife, he won't leave us, Norm.
Well, hey, so come back tomorrow. We want to hear your suggestions about how to improve this show in 2024. We'll hit the ground running after the first of the new year, and we won't stop until the year ends, or like Jason/Justin, until God decides we've had enough of you. But until that time, cherish the day, seize it, carpe diem. Life is short. Thanks for joining us. We'll see you tomorrow.
See you tomorrow, Norm.